Hello everyone. So this video is going to be about how the Salem witch trials influenced the American legal system. The main thing is that those accused lacked basic legal protections, and that included the whole innocent until proven guilty aspect that we have today. So, a little background in case anybody missed the other video. In early 1692, several girls in the colonial Massachusetts village of Salem began exhibiting strange symptoms, including twitching, barking, and complaining of being pinched or pricked by invisible pins. The afflicted girls soon accused several local women of bewitching them, beginning a flood of accusations that threw Salem and the surrounding areas into full-blown hysteria. The trials that ensued became a cautionary tale, as the accused lacked many of the legal protections that we take for granted today. By the time William Phips, the newly appointed royal governor of Massachusetts Bay Province, arrived from England that May, accused witches packed local jails. At the time, the colony was operating without a charter, since the Crown had revoked the previous one due to repeated violations. Phips brought with him a new royal charter that gave the colony's legislature the right to establish a court, but the process would take time and Phips had to act quickly. In a fateful decision, Governor Phips created a special court to try the accused witches of Salem. It was known as the Court of Oyer and Terminar, meaning to hear and determine. In the old Northern French, that was still standard in English courts at the time. While remnants of this legal language still endure in the modern American legal system, the phrase oyez, oyez, oyez began proceeding in the U.S. Supreme Court, amongst others. The Court of Oyer and Terminar bore little resemblance to the courts we know today. When an accused witch appeared in front of the Court of Oyer and Terminar during the Salem witch trials, the law assumed that they were guilty. Today, the presumption of innocence, or the idea that an individual accused of a crime is innocent until proven guilty, is one of the fundamental rights underlying the U.S. criminal justice system. With roots in English common law, the presumption of innocence is nonetheless absent from key legal documents such as the Magna Carta or the English Bill of Rights of 1689. It's not mentioned in the Constitution either, but statutes and courts' decisions, including the Supreme Court decision of Coffin v. United States in 1895 and Taylor v. Kentucky in 1978, later established the presumption of innocence as one of the basic requirements for a fair trial, something none of the accused witches of Salem received. And that also goes back to the werewolf trials too. Nobody was innocent until proven guilty. Admission to hearsay evidence and lack of defense counsel has also changed. Law school professor Lynn Nyhoff, that has taught seminars on the Salem witch trials, says that the U.S. legal system, including two vital protections that were absent in Salem, making the tragedy almost inevitable, is the omission of hearsay evidence and the lack of defense counsel. The first is the hearsay rule, a complex legal doctrine that essentially prevents the use at trial of statements made outside of the court. Today, the hearsay rule plays a critical role in ensuring that the evidence admitted is reliable and is based on personal knowledge of witnesses. It prevents the admission of rumors, assumptions, and community gossip, precisely the sort of things that drove the Salem witch trials. Debate over allowing hearsay in court trials had begun by the time of the Salem witch trials, but the doctrine evolved slowly. In a Harvard Law Review article published in 1904, J. H. Wigmore wrote that the history of the hearsay rule as a distinct and living idea begins only in the 1500s, and it does not gain complete development and final precision until early 1700s. The second key legal protection that accused witches at the Salem trials lacked was the right to be represented by counsel. There were no defense lawyers present or allowed at these proceedings to object while their clients were being questioned, or to cross-examine those who testified. The inability to cross-examine was particularly damning because most of the witnesses against the accused witches could have been very effectively challenged. The court of Oyer and Terminer also relied heavily on spectral evidence. This evidence, according to USLegal.com, refers to a witness testimony that the accused person's spirit or spectral shape appeared to him or her witness in a dream at the time of the accused person's physical body was at another location. The court's acceptance of spectral evidence was controversial from the start, as it differed from accepted legal practices at the time. Following the execution of Bridget Bishop, who became the first accused witch to be hanged on June 10, 1692, Governor Phipps asked a group of the colony's leading ministers, including Increase Mather and his son, Cotton, for their opinion on the witchcraft proceedings and the use of spectral evidence in particular. In a response written on behalf of the group, Cotton Mather urged caution regarding spectral evidence, suggesting that the devil could in fact assume the shape of an innocent person. But the statement closed with support for the court, as the ministers encouraged the speedy and vigorous prosecution of such as have rendered themselves obnoxious. Despite the minister's tepid warning, the court of Oyer and Terminer continued to convict accused witches on the basis of spectral evidence. The crisis reached its height in late September 1692 when 7 women and 1 man were hanged as witches on a single day. By then, however, public support for the court was waning. Increase Mather went public with his strong opposition to use the spectral evidence in witchcraft trials in early October, arguing that his treatise Case of Conscience that it were better that 10 suspected witches should escape than 1 innocent person be condemned. It's important to note that the trials didn't end because people stopped believing in witches. They ended because people stopped believing that the trials were doing an effective job at identifying who the witches were. Legal legacy of the Salem witch trials. On October 29, 1692, Phipps dissolved the court of Oyer and Terminer, a decision that marked the beginning of the end for the Salem witch trials. By May 1693, Phipps had pardoned and released all those remaining in prison on witchcraft charges. In the years to come, judges and juries, and even one of the main accusers, apologized for their roles in the trials. Then, in 1711, Massachusetts passed legislation exonerating those executed as witches and paying restitution to their families. Nearly a century after the crisis in Salem, during debate over ratification of the Constitution, anti-federalist Delegates successfully argued that the document needed a Bill of Rights to guard against the violation of individual citizens' fundamental freedoms by the federal government. Such arguments may have implicitly drawn strength from the negative example of the Salem witch trials, when accused witches were deprived of even the most basic rights they should have been granted under English common law. That lesson continued to resonate in the centuries to come, especially during periods of crisis such as the Red Scare, the McCarthyism, and the Cold War era. It is in view difficult to draw a direct line from the Salem witch trials to a specific existing legal document, but it's arguable that they have had an immense influence on how we think about the law. The trials are filled with cautionary tales about how catastrophically bad things can go when legal proceedings fail to offer certain minimum guarantees. They also provide a perpetual reminder of the consequences of fear, unchecked by the sort of reasoned judgment that the law demands. So there is a little bit about how our history has shaped the way that we do things in today's world. Have a good day, everybody.